Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, Law Street Media, and Fastcase. I'm your host, Tom Hagy. To understand the multi-billion-dollar market and the demand for hair products made specifically for Black people, and I think we're safe to say it's mostly women we're talking about here, you have to start all the way back at slavery and for way too long after emancipation and well after the civil rights movement, and even today for that matter, and how white people perceived or perceive Black people based not only on the color of their skin and facial features, but on their hair. Pressure put on Black Americans to look more like white people by society in general, and in this case we're talking about advertisers and marketers, is considerable. How's that for understatement? And we're talking about pressure that's put on Black children as well, especially on Black girls who are trying to fit in, like all kids do. Straight or flattened hair was and continues for many Black women and girls to be the objective. The cosmetic industry gave them a solution. However, studies have suggested that women are paying with their health. And now beauty giant L'Oréal and other manufacturers have found themselves slammed with dozens of complaints that the products marketed to adults and children alike are causing users uterine cancer and other diseases. Plaintiffs claim this is the result of endocrine-disrupting chemicals in these products, some of which are used frequently, weekly, and for years. Some girls start to use them even before they are teenagers. Plaintiffs claim this is the result of the use of endocrine-disrupting chemicals in products that are used frequently, weekly, and for years. Some girls start to use them even before they are teenagers. In addition to uterine cancer, consumers are claiming a connection between these products and breast cancer, uterine fibroids, endometriosis, and preterm deliveries among pregnant women. A 2022 study, for example, that was led by the National Institutes of Health reported that women who frequently used chemical hair straightening or hair relaxing products are more than twice as likely to develop uterine cancer as women who do not. With more than 60 class actions filed, they've all been consolidated in an MDL in Chicago over L'Oréal's objection, which preferred to litigate in New York. With me to talk about this litigation is Jennifer Hoekstra, a partner with Aylstock, Witkin, Kreis Overholtz. Jennifer is a veteran plaintiff attorney in the world of complex and mass tort litigation. A lot of her cases have dealt with drug and device litigation. She's continued to play a leadership role in various actions. She has a Bachelor of Arts degree in environmental science from Columbia College at Columbia University in the city of New York. She relocated to Louisiana, which is nothing like New York, to attend Tulane Law School, where she earned her JD while also completing her certificate in environmental law. I spent 2 minutes talking with her and realized quickly she's someone who has a grasp of a ton of facts and details and shares them in ways, even I can understand. And so can you. Here's my interview with Jennifer Hoekstra. This is my second interview with her, and it's a pleasure. I hope you enjoy it. All right. Well, Jennifer Hoekstra, thank you very much for talking with me today.
Not a problem. Good to see you.
The litigation. So if you could give me some history first on the use and sale of hair relaxers in America, and why is that history important to the litigation?
I think that, the history of African-American or brown Black women's hair in this country has a long history of, racial discrimination that's associated with it. I mean, even looking at like the Crown Act in certain, states where, you're allowed to wear your natural hair to, school and the workplace, wherever it may be, goes along with that because there's, for hundreds of years, we've told, brown and Black women that in order to look more professional, in order to, be well received, they needed to look more white. Their hair needed to be straighter. They needed to, not have kinky hair, essentially. And what it's come down to is, over years, it was, between covering your hair in public, between, using, grease and a flat iron, essentially, at various points to make it, as straight as possible. Various tools have been implemented. And for the last 50 years in this country, it's been a series of chemical hair relaxers. And those chemical hair relaxers, in all honesty, and somewhat alike to the talc situation in this country, the talc litigation, there are generations of women who think they just have a family history of ovarian or uterine cancer because their families use this product. Most women who use hair relaxers start as young as 9 or 10 years old in middle school. And what essentially occurs is over their teenage years, as their hormones are fluctuating, these chemicals are interacting with their body in a way that is causing them a predisposition towards cancers. So that's basically kind of where the history has led us to. Obviously, the science and like the correlation between African American women have a higher risk of uterine and ovarian cancer. Is it genetics? Is it an actual, is there a reason for it, as opposed to, some other environmental effect or, other relationship, has been like an ongoing issue in the back of everyone's mind. But the science really wasn't there until last fall.
Okay.
And in 2021 and then fall of 2022, there were several studies looking at uterine and ovarian cancer that didn't just ask the question, are white women or Black women more likely to have uterine and ovarian cancer? What it asked is, are women who use hair relaxers more likely to? And they asked about the frequency of use. And for the first time, there was an actual scientific correlation between women who use hair relaxers more than 5 times a year and uterine cancer.
Okay.
And that has kind of, triggered this entire, litigation that's occurring.
Okay. So that was just a change in how they looked at statistics. They said, so they asked the question differently.
Yes, it's not even just, it's not even just that they looked at the question differently. It's certain types of cancer seem to be more associated with certain chemicals. Great, we know that. Certain types of cancer seem to be more associated with women of a certain demographic. Great, we know that. And the science really hadn't pushed beyond that in terms of, is there a specific correlation between those two interplays until fairly recently. And the wonderful thing about that is that the change in the science, the refocus, has led to additional money for additional research. It's led to lawsuits, which actually pulled these products from the actual shelves in certain locations. So it's been like a whirlwind of movement in the last 6 to 7 months, in terms of, you can have an idea that it's really causing it. You can have a suspicion. You could tell people don't use hair relaxers but it's the first time you could point at a specific science argument and be like, this is proven there's a statistically significant risk.
Okay. So is uterine cancer the main injury, or are there others?
Uterine and ovarian cancer are the main injury. And for those people who are doing TELC cases, it's not the same type of ovarian cancer as the TELC cases, which makes it a little bit easier to differentiate. A lot of people actually were unable to take on certain cases because for TELC, because it was serous versus non-serous cancer. Which way was it? Which one is scientifically correlated? And hair relaxer actually is correlated to non-serous cancer, which isn't the same type that's dealt with TELC. Okay. So there's a lot of, science, and, you have to get into the actual pathology to make the determination of whether there is a scientific link. But both for certain types of all uterine cancer, for certain types of ovarian cancer, there's a statistically significant correlation to women who use hair relaxers more than 5 times a year.
Okay. I got it. All right. I guess in my memory, a signature disease like mesothelioma that was tied, rather than just a general lung cancer, that particular illness was tied to that exposure.
There's discussion out there because there are fibroid cases, fibroids with the hysterectomy, breast cancer. There's certain other types of hormone-related cancers, but the correlation isn't there as statistically significant as it is with uterine and ovarian cancer, which is why that's the focus on the litigation.
And you started to talk about this, so I was going to ask you, but before the classes, before there was litigation, were there attempts to address consumer concerns, like at the regulatory level?
Yes, obviously there have been, concerns about what we call endocrine disrupting chemicals, or EDCs, which are the main focus of the chemical compounds that are involved in these hair relaxers, phthalates, those sort of things. As one would expect, there's a lot of restrictions about their use and sale in the EU, and they've been taken off the market in other parts of the world, but that hasn't happened yet in the US. There's still a review of the regulatory process, but again, in the US, the FDA, it's a cosmetic, right? It's an over-the-counter cosmetic. which has less restriction than one would expect for pharmaceuticals or other things. So the approval process is not as clean as you would expect it to. It's also interesting because labeling on these products, in the cosmetic industry for trade secret purposes, you can hide up to 20% of your actual chemical formulation by labeling it fragrance. Well, the chemicals that we're talking about that cause this are normally the binding agents in fragrance, in addition to being part of the actual chemical product. So knowing the exact, mechanism, knowing the exact compound is already hidden under the regulatory system that we have in the US. So that's it's being addressed, and it's obviously ongoing discussions, but there's no real legislation to change it. Although the new changes in the Cosmetics Act that have been proposed in the last two sessions of Congress may change that moving forward, but it hasn't restricted any sale of phthalates, various EDCs, those sort of things. They're all still in the market. Okay. They're all still in these products.
And you mentioned this too, that there were cases that did lead to some action being taken to get these off the market. So before the class actions, were there some individual cases that we should be aware of?
So the first case was filed by DeCello Levitt, Ben Crump, and a couple of other firms for Jenny Mitchell in the Northern District of Illinois in October of 2022. That led to a lot of firms who'd been talking about the science and whether it was there, and this prevalence that we'd seen even in our other cases, in our talc industry, or in our talc cases, looking at those where we had people who, they used talc, but they didn't have the right type of cancer, but they'd also said that they'd used hair elixir, and there was a type of cancer that was associated with that. There'd been correlations for years that people had kind of looked at, which is what led to, several hundred cases being filed last fall. Our office filed several class actions. I think we have 5 or 6 of them around the country that we're involved with, more for the consumer aspect of it, because after that first case was filed, the manufacturers, L'Oréal, Revlon, Strength of Nature, Namaste, they pulled the product from the shelves kind of voluntarily, but there was no agreement that they would stay off of the shelf forever. It wasn't done because there was, an actual recall. It was just they had really bad consumer attention. They pulled it off. And when that happens, at some point it will come back onto the shelves and people will assume it's safe because it's back and it was gone. So they must have changed it, which is part of what we're looking at in the litigation on terms of the class and consumer side, is how do you represent people who purchased something thinking it was safe, had to, no longer can use it because it's not safe, but haven't had an actual injury yet. Especially with cancers, we're well aware of what the medical monitoring aspects of it could be for 25 plus years, whatever the usage is. So that's part of why the consumer cases, the class cases, were so important for our firm to file. But because of the correlation between the consumer cases and the personal injury cases, they've both been pulled into a MDL in the Northern District of Illinois that was put together in February by the JPML. It was argued in January. And the leadership structure was actually appointed in March of 2023. And we're moving forward with a 30-plus member, plaintiff steering committee structure, getting ready to address all of these concerns as we get into discovery against, 8 or 9 different defendants who've sold variations of these products.
So can you give me a scope of how many cases there are, how many potential claimants there are?
Statistically, given the use of hair elixir in this country, the volume of African-American women who have uterine ovarian cancer, it would be safe to say probably 20,000 perhaps cases. We're obviously, not there yet. We're trying to do some internal, plaintiff side discussions to see how many cases we think there will be. For a cancer litigation, it's fairly large. It's significant. But we're not talking, the mass litigations like, opioids or, the 3M earplug cases were. These are definitely personal injury cases. They're very specific to a certain, demographic of the population. And these cases, in all honesty, these are not the type of cancers that always result in fatalities. So it's not as much. What it does result in is, a lot of women, young women in their, 20s and 30s who are permanent infertility, inability to have children, and a risk of ongoing hormonal issues for the rest of their lives. It's a very tragic situation.
Yeah, definitely is. So these questions may overlap, but so what are the claims relating to the manufacturing of these products, and then claims related to, say, marketing and sales?
So a couple of things on the marketing and sales. There's formulations that are out there that are just like the label literally is just for me. There's one that's branded towards children's use. It has a picture of a smiling, young girl on the cover with straight hair. There's an expectation that, the marketing push here was, hey, look at this beautiful, soft, shiny hair. You too can have it. And it looks completely safe. And it's, sold in your drugstore or neighborhood market. A lot of the use of this was home use. People, their mothers would put it on their hair at home before a special event. It's referred to in some circles as creamy crack because once you used it, you couldn't go back. Like there's a jingle that everyone of a certain age and generation who's, who fits into the demographic of people who would use this could sing in the back of their head because the commercials were so prevalent. And the marketing was basically directed at, this is safe. This is, easy use, home use. So it seems to be, it's non-toxic. And then you start digging into the actual chemicals that are there, into the actual side effects of them. And some of it is, the plastics that are in it, the endocrine disrupting chemicals that are in it, they're pretty prevalent in a variety of, situations. But this specifically, it's the interaction we believe between the hormones and the hormones that are in the product, which are helpful for, the relaxing of the hair, as well as the individual hormonal fluctuations of people as they go through puberty, which has caused this very, very specific targeted hormone-related cancer to develop. And I think the marketing, sorry, go ahead.
No, I was just going to ask what you can talk more about the marketing. I was going to ask about what the warning labels and instructions say for use of these products, but
not much. And like everything else in this country, everyone thinks that the FDA has approved something. It's obviously safe for use. It's the same with this as it is with most pharmaceuticals. It's an interesting interplay of litigation where you have firms who've done pharmaceuticals, firms who've done, cancers, women's, specific injuries, and firms who have more of an environmental bent that are involved in it. The science is still developing, finding out the specific component and the specific, the specific element of the product will take time. This isn't publicly available information. This is information that's going to have to come from, the defendants themselves. We don't even know if, what the formulations have changed over the years. None of the packaging has changed significantly in about a 10-year period. So there's an assumption that it's, the same product, but knowing the specific aspects of it is part of the initial discovery of litigation. We know that there's correlations. We know that there's the science, the studies that I mentioned that came out in 2021 and 2022, they have specific formulations that they tested. Those are the specific products that are at the central part of this litigation. They're the specific, ones that we're looking at in terms of representing people. But knowing exactly what's behind the curtain on those products, it requires individual testing of products until we get lot information from the defendants. So that manufacturing component of it is going to be ongoing, making sure that we have all of the information. Like the marketing and sales case is so much stronger because we know what it looks like. And it looks like they were targeting a specific, population, a specific group, even a specific age range to get them hooked on this drug get them hooked on this product to use over and over and over again. I mean, it's one of those things where, you ask people the question, did you use the product more than 5 times a year when they come in? And the response is, what are you talking about? I used it monthly. I use it more than monthly for 15, 20, 30 years of their lives.
Yeah, it's there. That's what it's for, right? Like shampoo. Yep. So maybe it's too early, but do you anticipate there'd be subclasses of plaintiffs? Or?
I think the depends on how the case progresses. I think that certain states allow medical monitoring. We definitely have consumer claims and, all of the states that are possibly available. And there'd be some, overlap between the marketing case for the personal injury claims and the consumer claims themselves. But a lot of that information, again, is going to come from the tracking information that some of the defendants had, how sophisticated some of them were. The interesting development of these products is that a lot of them were locally based. It was, some drugstore in Baltimore in, the 1970s started, developing one. Some drugstore in Chicago in the 1970s started developing a product. And they all had kind of regional brand recognition. But over time, they've been purchased by L'Oréal and Revlon and Godrej and Daber and these large, multinational conglomerate companies who do cosmetics. but a lot of people still think it's the mom and pop store in their town that, that developed it. And part of their, viewpoint on it is these people are like me. They wouldn't have done this to me. So, putting the pieces together of who knew what when and if, they knew what the risks were of the specific chemicals is going to be an interesting portion of litigation, regardless of whether we're talking consumer claims, medical monitoring, classes, or if we're talking, a personal injury litigation itself. And I will say I'm kind of straddling both because our firm does represent both personal injury claims and the class actions.
I mean, whenever there's something there's a toxic type tort, dose is always an issue. I wonder, the science probably isn't there yet, but if you use it once a year, is that one thing? If you're using it every week, is that something else? I have to assume that will be, but that's obviously, I'm not a scientist.
No, that's definitely part of it. And I think that was the interesting thing when I keep saying, like, did you use it more than 5 times a year? The studies that have come out refer to frequent use as more than 5 times a year. And there's a correlation there where if you have occasional use, which is listed as 4 times a year or less, there's not as strong a correlation. So we are thinking it is dose related. We are thinking that it's, ongoing exposure. There's still, research being done in terms of the latency and those sort of, pieces of it. But it is definitely going to be dose and exposure related as most toxic torts are.
So what kind of defenses are you seeing, or do you anticipate?
Well, the first one is that our complaints are not well pled because we haven't said with specificity the lot and exact chemicals that are causing the injury for each and every person. We're also going to have a lot of defenses in relation to the fact that it's an over-the-counter product. There's no prescription required. And there may be brand loyalty. There's also loyalty to your pocketbook. And if you walked in one week to pick up your hair relaxer and one was on sale versus another, people are using different products at different times, and the use may or may not overlap. So we're seeing a lot of that. I think we can get around, the basic, affidavit of use, proof of use aspect of it. We're not overly concerned with tracking receipts for the last 15 years for people to know, the specific information. But I do think that another defense that we're going to see is that it's not our product, it was their product. Ours is safer than theirs. And the defendants are going to start pointing fingers at each other, which obviously gets very difficult when you have a case where you filed against multiple defendants because they use multiple products over time. The other interesting aspect we've been dealing with is Revlon filed bankruptcy last summer before this litigation came about, before anyone knew this litigation would exist. And the Revlon bankruptcy plan actually was paused so they could reopen the claims period for hair relaxer claims. The claims submission period for hair relaxer claims expired on Tuesday. And the bankruptcy plan was approved a week ago to come out of bankruptcy with the insurance addressing certain claims. And I think there'll be an ongoing interplay between claims made against old Revlon versus lawsuits against new Revlon in the bankruptcy or in the MDL. At this moment, Revlon's not in the MDL because no one could file a claim against them because they were in bankruptcy and had bankruptcy protection. But I do think that the Revlon defendants that are not yet there will have a different point of view, and they will have a different amount of information because bankruptcy claims were filed for thousands of people against Revlon to ensure that their claim was protected. And those same individuals may or may not already have a lawsuit in the MDL. They may be within their statutory timeframe and will be filing shortly. So Revlon is going to be coming into this litigation with a better idea of the volume of claims against it than the other defendants.
So once again, you find yourself in that sweet spot where mass torts and bankruptcy come together.
It's all I seem to do these days, yes.
Quite a specialty. When you were a little girl, that's what you wanted to do. Let's see. So, no, you've already talked about similar litigation. You've mentioned talc as a somewhat similar analogous kind of litigation. Yeah.
Yeah. I also think that there's several individuals. Mike London is one of the co-leads. Fidelma Fitzpatrick with Motley Rice, Mike London with Douglas and London, Deandra DeBross Zimmerman is from Detella Levitt, and Ben Crump from Crump Law are the 4 co-leads. Mike London and I have worked together on the proton pump inhibitor litigation, which in terms of dealing with multiple defendants with over-the-counter products that overlap is very similar. And I think that dealing with discovery as that works in terms of like multiple defendants at the same time, similar to, opioids and, some other litigations, is going to be a very, very, focused of everyone to make sure that we're not focusing too much on Revlon. We're not focusing too much on L'Oréal. We're focusing on all of the products, and that discovery is working and moving forward, cooperatively against all of the defendants at the same time. Because I think that aspect of it, not letting one defendant get too far ahead of the others, is the real way that we can protect all of our clients' claims.
So what do you hope to accomplish? What is it you want to get out of this litigation for your clients in these classes?
I would like a lot of little girls to stop putting chemical hair relaxers on their hair and understand what the risks of it are. These companies who followed through with what we think are frankly irresponsible marketing practices, to realize that it's sometimes not just about, a product line and, making a little bit of money, but that there are real risks associated and there are real people behind it. I do think that sometimes, depending on the scope of the litigation, this could end up, similar to opioids or talc, where there's, an actual legislative reaction. There's some sort of, further limiting on the product. And if we could keep some of them off of the shelves for as long as humanly possible, or have an actual agreement that results in them not being sold commercially, that would be an amazing result. Well,
there'll be a lot of publicity around it as well. I'm sure the litigation will also spark awareness to help with that cause. But so Jennifer Hoekstra, thank you very much for talking with me about this today. I'll turn this around. Thanks. I do appreciate it. And if there's anything else you ever want to talk about, let me know.
Absolutely. We're looking at the eye drop cases currently, so I'll let you know in a couple of weeks if there's something there that we want to talk about. Similar issue, except for the fact that it's an overseas defendant that no one can actually tell if they are viable or not. So we're trying to figure out how big we want to make it before we, end up in a situation where the only people with money are Amazon and Walmart, and they're not eligible for lawsuits.
What's in the eye drops?
Esricare and Delsum, it's an eye drop that's supposed to help with like dry eyes when you're in like certain medical conditions. They actually have caused serious infections and scratching of cataracts and permanent loss of vision for several hundred people. There was a FDA alert recall. FDA actually sent someone to investigate the facility in India and basically shut it down based on how many violations it had. So it's another example of, international supply chain and how it can really impact you right at home, because you assume, since it's for sale on Amazon or you can pick it up at Walmart, that it's, safe and follows all of the approval process that we would have in the US. And in reality, it's coming over from overseas in large batches, and it's just being warehoused in the US.
Are you involved at all in the one with the benzene and the dry?
Yeah, my firm is. Yeah, no, we're doing the dry shampoo. If you want, I can get you in touch with my partner, Jason Richards, who's kind of central to that, and see if he's available for a discussion.
Yeah. Okay. I'll send you a note to remind you, just in case. All right. Jennifer, have a good day. I
appreciate that.
Take care.
Thanks a lot.
That concludes this episode of the Emerging Litigation Podcast. If you have any questions about anything you heard on the podcast or would like to participate, please write to me at editor@litigationconferences.com. The Emerging Litigation Podcast is a co-production of HB Litigation and Critical Legal Content, my companies, and Fastcase, and our friends at Law Street Media, David Nair, Editor-in-Chief. This is also the audio companion to the Journal on Emerging Issues in Litigation, published by Fastcase, Full Court Press. Tom Hagy, Editor-in-Chief, Morgan Wright, Publisher. I'm your host, Tom Hagy. That's why I'm talking, and I don't know if it needs to be said, but this is not legal advice. Unless telling you it's not legal advice is legal advice, although I'd argue it's just plain common sense. Thanks for listening. Give us a rating, share with friends. See you on the next episode.